Hi, this is Mr. Evans. This video looks at competition law, part of the legal environment. So we're conducting our PESTLE analysis, looking for opportunities and threats in the external environment. This will consider the government and legal requirements in relation to competition. So first of all, before we look at the impact of competition law on UK businesses, let's just consider what a competitive market is. And a competitive market is considered to be one where many producers are in competition with each other to meet the needs of many consumers. Okay, so that's kind of an economicsy type definition of almost what a perfect market is. In reality, you don't need to have many producers to have a competitive market. An example of a very competitive market in the UK would be the supermarket industry, where there are the big four, Tesco, Sainsbury's, Asda, Waitrose, and you've got a few others. You've got the discounters like Aldi and Lidl, and then you've got Marks and Spencer's kind of at the top end as well. So that's what, 6 or 7 big companies, but that market is operating fairly competitively. There's fairly fierce competition in that market for consumers. So the point is that when a market, when firms are acting in a competitive way, it's going to have several benefits, and these will include more choice for consumers. Okay, we can go to Waitrose at one end, we can maybe shop in the middle somewhere, someone like Sainsbury's, or if we're really concerned about prices, we might go to somewhere like Lidl. Okay, so competitive markets provide more choice. On average, there should be lower prices. If there was only one firm in the supermarket industry, they could charge consumers what they want because they couldn't go to anywhere else. There should lead to better quality and service. If businesses are fighting between each other to attract consumers, they're going to want to differentiate themselves through things like better quality goods, better customer service, more friendly staff, better opening hours, all of those kind of ways of competing and basically gaining a competitive advantage. So what are the benefits to firms of competitive markets? Well, ultimately there's the profit motive, which means that the businesses that are best able to meet the needs of customers are going to attract the most customers and therefore make the most profit, which is an incentive for businesses in competitive markets to become, one of the top businesses. So that brings us to how competition law in the UK is enforced and what it aims to do. So the first aim of UK competition law is to reduce anti-competitive practices, and this would include things like price fixing, which is illegal, where firms get together, let's say in this that Sainsbury's and Tesco, two huge supermarkets, get together and they say, look, you increase your price for carrots to £1 per kilogram, and we'll do the same, and people who are desperate for carrots won't be able to go elsewhere because we've set the price. There's no point in people changing. We make more profit. Okay, so a very stupid really example there, but price fixing is illegal. Also illegal is predatory pricing. This is where a dominant firm in the market, a really big firm, may decide that they're concerned about a new entrant to the market or a smaller firm in the market, and what that dominant firm might do is they might cut their price to the point even where they're making a loss on each sale. Now the reason that they would do that is they know that they've got the scale, they've got the resources to compete for a while whilst making a loss. They can survive, they can drive their competitor out of the market, and then when their competitor is gone, they can raise their price again and dominate that market. So that's actually illegal as well, and something that the CMA, who I'll mention in a minute, the Competitions and Markets Authority, try to make sure that they are regulating. Things like limiting output, which would cut the supply of a good onto the market. Obviously, when something is scarce, the price goes up. Supply can't satisfy demand. So any organisation or group of organisations that are thought to be limiting their output in order to drive up prices, that would be an anti-competitive practice. Or any organisation engaged in unfair trading terms. So organisations might be, so for example, if you've got a little corner shop who's got a number of suppliers, let's say they really want to stock a new brand of crisps that's come out, and that supplier of the crisps said, well, you're only going to buy the crisps, we're only going to sell you this brand of crisps that you really want. You also take our water and these chocolate bars that aren't quite so popular. That would be an uncompetitive trading practice. Or if they said, okay, we'll sell you these crisps, but we don't want those other crisps on the shelf. All of those kind of things would be unfair anti-competitive trading practices that are illegal under this aspect of UK law. So not only do we want to reduce anti-competitive practice, but we want to prevent that from occurring in the first place. So we would look to, so mergers and acquisitions is something that you're going to study a lot more in this A2 course, but we looked a bit at mergers and acquisitions at AS. In terms of competition law, anything that's going to result in the creation of a firm with excess of 25% of market share would be considered a legal monopoly and probably wouldn't be allowed under UK competition law. So main things that the main aims of UK competition law: number one, reduce anti-competitive prices; number two, prevent mergers that would result in uncompetitive markets occurring, and any two firms coming together who would have a joint market share of over 25% would probably not be allowed under UK competition law. So who oversees competition law in the UK? Well, it's an organisation called the Competitions and Markets Authority, the CMA. This overtook, there have been quite a few of them. There was the Office of Fair Trade, the Monopolies and Mergers Commission, and in 2014 the CMA was created at the same time as the FCA, the Financial Conduct Authority. The Financial Conduct Authority look after banks and insurance companies in the finance industry. The CMA look after pretty much everyone else. So what do the CMA do? Well, number one, they investigate mergers which could restrict competition, i.e. mergers that are going to result in one firm having a dominant share in that market. They investigate markets to assess competitiveness. So even if there hasn't been a merger, they might decide to investigate, say, the supermarket industry, just to check that it is behaving in a way that is competitive. They might investigate where there have been abuses of dominant market positions, predatory pricing, price fixing, etc. Part of their role is to enforce consumer protection legislation, things like the Sale of Goods Act, when consumers have a right to buy products that are basically safe for them to buy, and the products are as described by the company. Finally, cooperating with sector regulators. I mentioned regulators in a previous business, organisations like Ofwat, Ofcom, and making sure, Ofgem, making sure that these regulators are actually doing their job and monitoring the energy market, the telecommunications market, making sure that they are doing their job and making sure those markets are acting in the best interest of consumers. So that's the role of the Competition and Markets Authority. Well, let's have a look at the opportunities and threats. So small businesses have the opportunity to compete with larger ones as a result of UK competition law. So small businesses looking to expand, merge, they may be able to as a result of this. Small businesses might be able to penetrate new markets where there are dominant businesses. Predatory pricing isn't allowed, which creates opportunities for businesses to expand, diversify into new markets. There are opportunities for mergers and acquisitions which improve competitiveness as long as they don't restrict competition in the market. So mergers and acquisitions can be beneficial for consumers. Two firms come together, it increases their economies of scale, as long as that doesn't breach that 25% market share kind of magic number, then that might be beneficial for consumers and should be legal under UK law. However, businesses should consider their pricing strategies. You know, when setting their prices, might they get in trouble with the CMA because they're setting a price that's quite low and might be considered anti-competitive, predatory pricing? Or have they kind of acted with their rivals, and are they setting an artificially high price in order to maintain profit margins? And there are the costs of monitoring businesses' practices for managers to make sure they're adhering to UK law. Okay, so that's a brief overview of the legal environment, competition law.